Hello, welcome once again to Leto's Law. I'm Steve Leto. One of the things we've talked about in the past is when the police are allowed to search your car without your permission. Obviously, they walk up to you and say, "Hey, may I search your car?" And you say, "Sure, go right ahead." Well, then they can search your car. And so I've had people say, "Well, but Steve, the second you say no, they're going to go, oh, I smell pot. I think I smell the marijuana in the air. And if you've been smoking the reefer, then we can search your car." And so a lot of people have said this, and it's true. I've seen police officers in court when asked, what right did you have to search this car over the objections of the driver? They say, well, I smelled marijuana. And of course, if that's an illegal thing to be doing while driving, that is smoking the marijuana, then it could lead to a search. Well, here's the question. Is that search always going to be legal? And someone sent me this because they knew I'd be interested. And of course, that's a great thing to do because I am. And that is that in Pennsylvania, a judge has ruled that when the police searched a Pennsylvania man's car because it reeked of pot, doesn't mean you can search the car. In a case that underscores the confusion over the legality of medical marijuana, a Lehigh County judge has ruled in favor of a Germansville man who challenged his arrest for illegally possessing a handgun because police found the handgun after saying they had probable cause to search his vehicle because it smelled of marijuana. Timothy O. Barr's lawyer said Judge Maria Dantos' ruling could be the first step in changing a procedural rule that allows police to search a vehicle based on the smell of drugs alone. Quote here is, this case will put a spotlight on the plain smell doctrine in Pennsylvania, which police use far too often to invade citizens' privacy. That's attorney Joshua Caroli. And here's the deal. I can tell you right now, I've actually been in court and seen a judge go either way on this. I've actually seen a judge go, how far was the window down in the car? And the judge, and the police officer goes, well, it's down this far. And how far back did you claim you smelled the pot? And there sometimes is the belief that the police are just saying that because they just say, well, who's not going to believe us when we tell them we smelled pot? So Barr, the man in question here who was pulled over and his car was searched, has a valid prescription to use medical marijuana for an undisclosed condition, court records show. He was a passenger in his mother's car, which was being driven by his wife when state troopers pulled it over on Mack Boulevard on November 7th because his wife failed to properly stop at an 8th Street Railroad overpass. So police officers pull the car over, they say you didn't stop properly, so that's a traffic infraction. Then they say, oh, and we smell pot, we're going to search the car. But of course, if the pot smell's coming from the guy who is legally allowed to use it, no law's been broken. Troopers say they smelled a strong odor of marijuana coming from the car and informed Barr that gave them the legal right to search the vehicle, even after he showed them his medical marijuana card. The officers found less than a gram of marijuana in an unmarked bag inside a pill bottle, as well as a small amount of marijuana residue in the cabin area. They also found a loaded handgun wrapped in what troopers believed was Barr's jacket, tucked underneath the driver's seat. Barr is prohibited from possessing a firearm due to a prior conviction, according to court records. Barr was then charged with possessing a small amount of marijuana and the two firearms offenses. In the judge's ruling dismissing the marijuana charge and suppressing the evidence in the firearms counts, the judge said it was illogical, impractical, and unreasonable for the troopers to suspect illegal activity once Barr showed them his medical marijuana card. Of course he smells like marijuana. He's allowed to use the stuff. I used to jokingly tell people there's a outdoor amphitheater here in Michigan that used to be called Pine Knob. It's been rebranded with the name of a power company, and I refuse to call it that. So I'm an old timer. I call it Pine Knob. And Pine Knob is like a bowl cut into the side of a hill, and there's a stage at the base of the bowl, and there's a roof over the seating, and then there's a hill in the back, and you can get hill tickets where you just sit on the ground like a peasant. I'm just kidding. And you sit on the ground, or you can sit in the seats that face the stage. And on a calm summer evening, depending on what band you were going to see, there would be a wafting of smoke down the hill that would settle into this bowl. And anybody who left that place at the end of, like, say, an Allman Brothers concert, besides being deaf, would have a strong smell of marijuana odor coming off their bodies for about 12 hours. And I know because I don't smoke, and I stumbled out of an Allman Brothers concert at least once, partially deaf, and reeking of, as I used to say, pine knob. So that's that. Pennsylvania legislators did not contemplate that people with legal medical marijuana cards would be arrested and prosecuted for possession of marijuana in a package that is not clearly marked with a dispensary name on it. Such actions are merely means of hampering the legalization of marijuana for medical purposes, the judge wrote in an opinion that she filed. Prosecutors must now decide whether to move forward with Barr's case without evidence, or they could appeal the case to the state superior court. District Attorney Jim Martin said his office is reviewing the opinion and transcripts from the July 17th hearing in the case, and they've yet to make a decision on whether or not it's worth appealing. The judge wrote in the opinion that police officers' confusion over medical marijuana in this case exemplified a clear disconnect between the medical community and the law enforcement community that does need to be addressed. And I've had a lot of people ask me about this. Say, Steve, if I've got medical marijuana and I'm allowed to use it and I'm smoking and I'm driving, what's that do for me? So the state trooper who arrested Barr testified that she mistakenly thought that dried marijuana was illegal and could not be used for medical purposes. Good thing she's got medical training. Court records show that was her belief. Marijuana in flower and dry leaf form has been offered at dispensaries since 2018. Patients may not smoke dried medical marijuana, but must ingest it through a vaping pen, which emits an odor. You've already lost me, I'm sorry. The smell of marijuana is no longer per se indicative of a crime, Dantos wrote. With a valid license, an individual is permitted and expected to leave an odor of marijuana emanating from his or her person, clothes, hair, breath, and therefore his or her vehicle, like I said, or coming from an Allman Brothers concert. Had Barr been behind the wheel instead of in the passenger seat, he could have been charged with driving while under the influence of a controlled substance, even with his medical marijuana prescription, if in fact he'd been under the influence of it. The judge said she based her opinion in part on the testimony of Dr. David Gordon, a medical marijuana expert hired by the defense. He testified that there's no physical difference between medical marijuana and street marijuana, and that the chemical compound of both drugs is the same. Gordon testified that he advises all his patients to hold onto their dispensary receipts as evidence. Dantos noted that there are about 143,000 Pennsylvania residents with prescriptions to use medical marijuana. Among the conditions approved for medical marijuana use are chronic pain, anxiety, Crohn's disease, Parkinson's, opioid use disorder, and post-traumatic stress disorder. I wonder if it also helps with hearing loss suffered at an Allman Brothers concert. Caroli praised Dantos' ruling and said he believes that plain smell doctrine is unfair. I've also always thought it was a little bit suspect. How do you ever prove you smelled something? I can prove I saw something. Number one, I can take a picture of it. Number two, if I somehow recorded it or someone else saw it. But have you ever been someplace and goes, hey, did you hear that? Did you smell that? There's certain things that you can't, did you see that? Well, look, it's right there. If I can't hear it or I can't smell it, how do I convince you of that? There's no way to do it. It's obviously my word against everyone else's. But a police officer in court saying, yeah, I smelled it. Who's going to argue with that? So the attorney praised the decision and said, among other things, the problem is there is no test for it. That's true. You can't sample the air. It puts a chilling effect on all citizens' Fourth Amendment rights against unreasonable searches. That is, until this judge saw the light of day and said, you know something? The guy's the passenger in the car and he smells of pot. Guess what? He's allowed to. This is America. He's got a medical marijuana card. He reeks of pot. You might not enjoy that smell, but that smell is not the basis to conduct a search against the wishes of the people in control of the car. So that's the situation, at least in this one court in Pennsylvania. I assure you that whether this case goes up or another case goes up, you are going to see this case being ruled on in the future at higher levels of courts until somebody addresses it. We'll see what happens then. But for the time being, that's what's going on in Pennsylvania. Like I said, great stories like that. Keep them coming. Questions or comments, put them below. Otherwise, talk to you later.